An Introduction to Employment Law and Immigration by Dustin McCall. In this presentation, we're going to discuss why it is important for you as a businessman to understand immigration law. The reason is simple. America is an incredibly diverse country. In America, we employ a much more diverse workforce than you can find anywhere else on the planet. Therefore, it is only natural that at some point, immigration law will enter your business conversations. There are three primary areas that we need to discuss to bring you up to speed on immigration law. The first of which is temporary residency, also called the American Visa Program. Next, we'll discuss green cards, or permanent residency, and lastly, we'll discuss non-worker alien statuses. This conversation is sometimes made confusing by the many acronyms that are tossed around during the discussion. H-1B, L-1, EB1, etc. really create an alphabet soup of confusing terms that are not frequently explained. To begin, I will explain the most common types of employer-sponsored visas, the H-1B and the L-1. The H-1B is the most common, and it has seen quite a bit of press lately, as it has been in the news quite frequently. This visa, as you may know, is for laborers of special skill. And what does special skill mean exactly? This phrase occurs frequently during the visa application program. And basically what it means is a skilled worker who works in a skilled position and more than often will have some sort of college education to back up that skill. You should know that the H-1B visa has a very strict quota system. For the year 2011, there are only 65,000 slots available. And to give you an idea of the competition for these slots, all the ones for the current year were filled by January 27th. This is why many technology companies are seeking to expand the H-1B visa program. People such as Bill Gates have argued frequently in front of Congress that technology companies need H-1B visas to attract software engineers from countries such as India and China so that American companies can stay competitive. Sadly, the H-1B visa expansion has not yet happened. This has led many employees to ask for an L-1 visa instead. Like the H-1B, the L-1 visa is also for laborers with special skills, but it does have additional restrictions. The first of which is that the employee must work in a supervisory capacity or greater when he comes to the United States. Furthermore, the employee must have competitive knowledge or knowledge that will help your company to succeed against its competition. Making it even more restrictive, the L1 requires an intra-company transfer. That is, the foreign employee must have been employed at a foreign branch of your company for at least 1 year before transferring to an American location. If you do not have a foreign branch of your company, the L1 is simply not a possibility. The heavy restrictions of skill, knowledge, and intercompany transfer mean that the L1 is generally used for executive and managerial level positions. Both the H-1B and the L-1 differ from the standardized visa application system in several ways. The first is they are entirely employer-sponsored. Therefore, the employer, you, will bear the brunt of the paperwork and the cost associated with the process. Now, the high fees associated with the process do make it much faster than a standard visa application. And you should expect to pay between $2,000 to $5,000 per employee in application fees, plus legal fees on top of that. So, an employer-sponsored visa can be quite expensive. You should also know that both of these visa types are considered dual intent documents. They come in as a temporary visa, but they are completely transferable over to a permanent residency program. The most common type of permanent residence likely to come up for a business is employer-sponsored permanent residence. This comes in the form of EB1, EB2, and EB3 permanent residency. and by permanent residency we are talking about the green card program. You should know that each category of residency is limited to 40,000 applicants per year. Also, while each category is very similar, each one requires an increasingly higher level of education, with the EB3 requiring a minimum of a bachelor's degree and the EB1 recommending a PhD and requiring a master's for application. Once again, these types of residency are only available for those who have special skills and degrees in the arts or sciences. EB1, EB2, and EB3 residency has the benefit of being much faster than any other type of permanent resident application. However, once again, you as the employer will bear a significant expense in the application process. The only type of immigration faster than employer-sponsored immigration is, of course, illegal immigration. And sadly, this is the type of immigration law that will most likely come up to the businesses here today. There are several things that you will be required to know when dealing with illegal immigration. First, all employers are now required to file a Form I-9 with the Immigration and Customs Enforcement Agency. This form states that you, the employer, have verified the right to work and residency status of all employees in your company. Furthermore, these forms are audited by us annually, and you will bear any responsibilities if they turn out to be incorrect. In North Carolina, proper ID constitutes the ability to show two forms of ID that are correct and current. As an employer, you cannot specify what types of documents you will accept. That is, you cannot say, I will only accept visa and driver's license documents. If the document is suitable to the United States government, you have to accept that as a document. Furthermore, it is also considered discrimination to deny employment based upon the pending expiration of a work visa or other type of ID. You cannot deny employment to someone whose work visa will expire in 3 months. That is not a valid reason, and this is why it is important that you know about all forms of discrimination law. As an employer, you should never discriminate. Don't single out one group. While we all know that 90% of our illegal immigration problem does come from south of the border, there are still millions of legal immigrants from other countries, including over 1 million Canadians in the country illegally. Therefore, it is important to avoid stereotypes and associating illegal immigration with any one group. This problem is exemplified by the story of Simon Kirk. Simon was recently in the news because he was deported back to Canada. Simon had been working inside the United States for over 3 years, having never applied for a work visa. He said he was simply never asked for documentation. This might have been complicated by the fact that Simon was a skilled worker and actually a licensed veterinarian. This case signifies why it is important to properly document all employees, equally and fairly. So in summary, it is important to remember that America is a diverse workplace, and this makes understanding immigration law a high priority. Furthermore, we've learned that while complicated, immigration law is not as confusing as it would seem at first glance. And lastly, you need to know that you are required to understand the laws of immigration and discrimination. By knowing these laws, you can only prepare your company for any future issues that could arise regarding immigration and employment status. Thank you for listening to this presentation. I'll now be happy to accept any questions that the audience may have.